Okay. And I wanted to get on this as quickly as I could because I looked at the history of the case. And, I know it's a special designated as far as the District Attorney General's office. But I looked back at after this motion filed for extending the deadline for discovery. I realized there was going to be no agreement. The defendant opposed that, and I think from reading the document in response to Ms. Reguli filed, it's because I had anticipated the court date would stay the same, which is I think in the month of December 5th, 6th, 7th possibly. But it seems that if you give this extension, you'd want to change the court date, and so that's why we're having this discussion now. Am I correct so far, Mr. John Stevens? Is that your understanding, Ms. Reguli?
Yes, sir. I would add, Ms. Reguli and I did have a phone conversation about this. I think the concern for Ms. Reguli is that should we end the deadline in the end of July, she had no disagreement to that. Her concern is that there would be a deadline for motions to be filed in an August date in about 2 weeks after that. So I do think that that's a concern of hers, which is why she's not in direct agreement. She was okay for our verbal discussions to extend the deadline. However, she has a concern with the deadline of the motion filing date and hearings, saying that is so close to the deadline of discovery. But yes, sir, I believe that's why she filed, saying that there's not a direct agreement on everything.
And Your Honor, may I be heard?
Go ahead. Yes, go ahead.
So when Mr. Stevens filed his motion, I did ask him through email communication for some clarification as to what he needed. I didn't really get any clarification, and then through Your Honor's direction, through Mr. Garner, was for us to speak and see if we could reach an agreement. So when I was finally able to reach John Stevens by phone, he told me he needed until July the 31st to review the CASA documents. And as I don't know if you had the opportunity to look at them, but the CASA documents are 20 pages. And there are about 10 pages of policy and about 10 pages of a generated report, just in the spirit of cooperation. I told him, okay, however, that would put not 2 weeks, but if his deadline is July 31st, I think our motion date is August the 3rd. That's literally 3 days later. And there would be no way to be able to complete what I needed to complete. And honestly, then when we received the message from Mr. Garner that Your Honor was not in agreement with changing the trial date, that's when I filed that response. I think the state has had ample time. We are going on about a year since the filing of this indictment. And although through several Zoom meetings that we've heard, you've heard multiple comments from District Attorney Stevens about what he's going to do in preparation. And then he basically opposed, although he didn't file a separate response, he pretty much said he agreed with CASA's motion to quash. And so he didn't even want those records in the first place. So I am opposed to it. I think the state has had ample time. As we can now see, the state only has a hearsay affidavit and a hearsay witness, and I am anxious to be able to file the appropriate motions on this.
Anything back, Mr. Stevens?
Your Honor, Ms. Reguli filed a subpoena for records. We received those records after Your Honor filed her subpoena, well taken, the notes of it with some amendments. We did get ultimately back, as she noted, 20 pages. This includes about 10 pages of some reports, which my understanding include a lot of things that simply say deposit. The state did not, obviously I'm not, this is a pro tem matter. We did not ultimately indict this. I was not there during any investigative stage. There is no TBI involved in this. There is no Franklin Police Department involved in this. There is no investigative agency who was able to conduct investigation prior to this matter being pro-temmed, ultimately to be a case I'm looking at. Based on the information that Ms. Reguli has subpoenaed and I've received through the compliance with the subpoena, there are multiple items on this that simply say deposit over the years, and they do not put check, cash, from who, any details on these where the state will be able to go forward. The state does need to look at this and see ultimately, based on the records provided, if it would be comfortable enough to go forward with this trial, ultimately to be able to see this. I've been on the phone with Miss Emily Layton to do a fair ethical review of this case and to try to prepare this for trial, which Your Honor wants in the month of December, which is set. The state.
I'm going to interrupt you because that's not what I originally wanted. We got on board. We've continued this already, Counselor.
You're right.
Now I'm going to go ahead and say this too, because
Yes.
the defendant's correct. We're glad to have you on board. I'm
Yes, sir.
glad to be there for both sides to do what needs to be done from a judge's perspective. But we started way back on this, and I've heard this type of argument before: how much you had to do, how much you had to do, and we know the job of each of our jobs in the judicial system. And
Yes.
you were going to do a lot of things. She's right in pointing that out. It never got done, and I just can't see why we continue to have excuses. That's a trial date we worked on for December, and we set it with everything else up to that point being in place in fairness to both sides. So I'm somewhat just shocked that you come back always with excuses. I can't help it that as a judge, you don't have an investigating agency helping you. Whatever it is, you listed several, but that's not the point. If you're going to prosecute the case, you prosecute the case. If you're not, then do what you want to do as far as an all process. But it's time to stop. It's time to stop. Over with.
With that noted, I've spoken to the district attorney for this area, General Robert Nash. I've gone through it. I want to say on the record that CASA is a nonprofit who ultimately has a very tight budget on this matter. The state has went through these, and there are multiple things, including even an amount of $3,333 that was deposited in 2014, near the amount that Ms. Reguli must have made. There is no documentation. I've worked to try to see if I could ascertain any details of that, to be able to say what these deposits are, to be able to say with certainty at trial that they were not made by her. The state must prove in its burden that she did not make a payment, that ultimately she lied under oath and it was material to the case. And so the state believes that with these record keeping, while it appreciates CASA and its effort and its mission, there is some uncertainty to these, to the point where the state would have difficulty in proving beyond a reasonable doubt at trial what these deposits are, and proving a negative, which is that they were not made by Connie Reguli. I did speak about this with my elected on this matter, and the state will be moving to nolly this case. I wanted more time to look at it. However, I understand the court is correct that we have moved this. You're right, Your Honor. You're correct on me, asking for more time on this. I appreciate Your Honor on this. But I will say that at this point, we have a burden to move this beyond a reasonable doubt at trial. And with the records as they are with CASA, the state believes that with the uncertainty, the ambiguity on these deposits, it will not be able to carry that burden at this time. So the state would move to nolly this matter.
Certainly there'd be no objection from defense as far as an all process, correct?
Correct, sir.
I would ask the state, I appreciate your candidness. I hate it came to this point for that, but you know what the burden is. You've outlined your issues with the case. That's your job to assess the case. And I just ask that you immediately get me an order of null process. You put in that order, General, if you want to, why you feel that the state could not carry the burden of proof beyond reasonable doubt at trial. That's fine. It's still a short order, but let's get that order to us this week. Let's get it over with. And I don't know what else to say. I understand the state's position accepted. So the orders to come, it will be null process. We will clear our docket. General, you think we'd have that order? Can we get it by Friday? You going?
Yes, sir. There, the clerks are closed. Well, the clerk's office is closed for here, so there should be some time without court going on, so that shouldn't be an issue. I do have court this afternoon, but I will focus it, make it a priority tomorrow to be able to have that drafted and sent, sir.
Good deal. If there's nothing further, then I'll say best of luck to you and all people, and I'll on your end, and I'll just wait on that order. We'll go ahead and kick off our books.
And I just would just like the court reporter to just go ahead and transcribe today's hearing and just file that with the court as well.
Now, when you say transcribe it and file it with the court, for what purpose at this point? Now, she's got the record, and I take it she's the official court reporter, but are you going to pay for that?
Sure. Mm-hmm. I'll pay for the transcript for today.
Then if it's the same practice as it is or was in the 26th Judicial District, that's something that you would just ask that she gets you a transcript and you pay for it. But that would be